All the way down. You have a seat now until the judge comes out.
Good.
Your choice. I see you're reaching for the Bible.
You do swear that the testimony you are about to give to the court in this matter shall be the truth, the whole truth, and nothing but the truth. Please state your full name for the record. Thank you.
Davis, I just ask that you please keep your voice up so everything is being recorded. Are you presently under the influence of any type of medication, alcohol, substance, or drugs that could affect your judgment or your ability to understand these proceedings? Do you suffer from any type of physical or mental impairment that could affect your judgment or your ability to understand these proceedings? And how old are you, sir?
28.
Excuse me? 20. And your highest level of education?
Joining college.
Any difficulty reading or writing the English language?
No.
Mr. Belsky, have you had the opportunity to review the charges with your client?
I have not personally reviewed it with Mr. Davis, Your Honor, but I do believe Mr. Davis received by another member of our office, and one of the charges of Mr.
Are you
Davis.
waiving reading of the charges?
Yes, Your Honor.
All right, very good. Mr. Davis, you have certain rights. You have the right to remain silent. If you decide to speak and give up that right, anything that you say may be used against you. Do you understand that?
Yes.
In addition, you have the right to be represented by counsel. In fact, you're being represented by the Public Defender's Office for the purposes of this hearing. If you intend to hire an attorney at your own expense, you have to have that attorney file a notice of appearance prior to your next court appearance. Do you understand that?
Yes.
In addition, you have the right to have this matter presented to the grand jury and considered for indictment. If you are indicted, you have the right to a jury trial. You may also give up your right to indictment and a jury trial if you knowingly, voluntarily, and intelligently give up those rights or plead guilty. You're questioned to speak to your attorney before you decide to waive any of your rights or plead guilty. Do you understand that?
Yes.
In addition, are you an American citizen?
Yes.
Also, please be advised there are a number of programs that are available. There's something called the Pretrial Intervention Program, also known as PEI. That's available to defendants who are charged for the first time. They may be eligible for that program if that's something, and if you successfully complete the program, the charges are dismissed against you. I don't know if you're eligible for it or not, but if that's something that you're interested in, you should speak to your attorney. Understand?
Yes.
In addition, are you a veteran?
No.
Also, please be advised that there's a program called the Drug Court Program. The mission of the Drug Court is to stop substance abuse and related criminal activity through an intensive supervision and qualified substance abuse treatment and counseling. If that's something that interests you, you should speak to your attorney, and applications are available. Do you understand that?
Yes.
All right. So now we'll move on to the detention hearing itself, and before we get to that, let me just explain to you exactly what a detention hearing is. The state has filed a notice of motion for detention. Is that correct, counsel?
Yes, Your Honor.
All right. Do you understand that at a detention hearing, after a finding of probable cause, well, for this case, there is a presumption for detention because you've been charged with murder. Do you understand that?
Yes.
In addition, at a detention hearing, you have the right, and I should also tell you that that presumption can be overcome by a preponderance of the evidence. If it is overcome, then the state will have the opportunity to present evidence to the court for you to be detained. Do you understand that?
Yes.
At this detention hearing, you have the right to testify on your own behalf. You have the right to present witnesses, to cross-examine any witnesses that may testify against you, and present evidence to the court by way of proffer or otherwise. Do you understand that?
Yes.
Do you understand that if you do provide testimony during the course of a detention hearing, your testimony shall not be admissible in court on the issue of guilt and any other judicial proceedings related to proving these charges? However, your testimony shall be admissible in the following circumstances. In proceedings related to your subsequent failure to appear in court, proceedings related to any subsequent offenses committed while on release pending disposition of these charges, proceedings related to your subsequent violation of any conditions of release, any subsequent perjury proceedings, and to impeach your credibility should you choose to testify in any subsequent proceedings. Do you understand all that?
Yes.
Also, if the court, if you are detained in this matter, you have the right to be indicted within 90 days. So if you're detained, you'd be detained pending trial, and an indictment would have to be handed up within 90 days. In the event that you are indicted, you'd have to be brought to trial within 180 days unless there is excludable time. Do you understand all that?
Yes.
So in regard to the detention hearing itself, counsel?
Yes, Your Honor, I did have a chance to speak with Mr. Davis briefly before coming on the record about his rights to the detention hearing and what the court must find, just as Your Honor indicated just now on the record. I know Mr. Herman from our office also met with Mr. Davis, and I believe went over those rights as well. And after consulting with Mr. Davis, at this time, he agrees for the purposes of both probable cause determination as well as detention to consent to both findings of both. However, that's with the caveat, of course, that at any time, Mr. Davis has a right to reopen and contest both those findings and based upon further investigation or further evidence from the state.
Would you like to go over your client? Is that the state's understanding as well?
It is, Judge. The only thing I'll supplement, if I may approach, I have marked 5 exhibits, S1 through S5. It's my understanding those will be marked and received into evidence without objection. And they're just as they would go to probable cause in the detention issue. But that is my understanding. Thank you, Judge.
Mr. Belsky, would you go over your client?
Yes, Your Honor. Mr. Davis, before coming on the record here in court, I spoke with you briefly in Holden, right?
Yes.
And I told you that you had the right today to what's called a detention hearing, correct?
Yes.
And that at that detention hearing, the judge would have to make 2 findings. One, that there's probable cause that these charges occurred, not that you're guilty or not that these things happen, but just that there's probable cause that you should suggest or suspect that you committed this offense. And then 2, that there were no conditions that would allow you to be released, and that for the safety of the community and for your presence in court that you would be detained. Those are 2 findings you have to make about that, right? And you understand that you have a right to present evidence to support our position that there is no probable cause or that you should be released, right?
Yes.
And that at this time, based on our conversation, you were going to consent both to a finding of probable cause and to continue detention just for the time being, correct? And that you know you have the right at any time after consulting with counsel to reopen those issues and contest probable cause for your detention, right?
Yes.
All right, may I question your client?
Yes, Your Honor.
All right, you understand that you do have the right to a hearing in regard to probable cause and in regard to the detention hearing, is that correct?
Yes.
All right, you're waiving that right to have those hearings? And have you had enough time to speak with Mr. Belsky? All your questions been answered? Satisfied with his services?
Yes.
Has anybody forced you to waive your right to have a hearing for probable cause and a detention hearing?
No.
Are you doing it freely, voluntarily, knowingly, and intelligently?
Yes.
All right, then the court does find, based upon your testimony, that you've had a consultation with competent counsel with whom you're satisfied and have freely and voluntarily, without force or coercion, waived your right to a probable cause hearing and a detention hearing. And as a result of that, you will be detained pending trial. Again, an indictment must be handed up within 90 days, and if you are indicted, then you have to go to trial within 180 days. We're going to extend that time frame. All right, that will conclude the hearing. Thank you very much. The next hearing in the case.
Thank you, Judge. It's scheduled for February 3rd before Judge Taylor.
All right, thank you.
Thank you, Your Honor.
Thank you, officers.
Thanks. Appreciate it.
Do we have another case that's ready?
Yes, Judge.